Under what circumstances does getting punched in the face result in physical injury such as it can make out assault? To find out, you have to read People versus Wheeler, but it's 2 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I try to cover New York Court of Appeals cases in 5 minutes or less. This is the episode on the case of People versus Wheeler. The citation for this case is 2023 New York Slip Opinion 02736, published by the New York Court of Appeals on May 18th of 2023. The issue in this case is legal sufficiency for a charge of assault with respect to the term physical injury. To understand how this case fits in, you have to understand that assault in the second degree under Penal Law Section 120.05, sub 3, it states that with intent to prevent a police officer and a variety of other people, but for the purpose of this case, with the intent to prevent a police officer from performing a lawful duty, if the person causes physical injury to that police officer, it's assault in the second degree, which is a D violent felony. But physical injury, as that term is defined under Penal Law Section 10.00 sub 9, and that's defined as impairment of physical condition or substantial pain. And there's been volumes of cases that fall on one side of the line or the other side of the line. Cases have basically said that if you slap somebody and they don't cause injury, that's not a physical injury. Mere pushing or poking is not physical injury, but breaking someone's bones or cutting someone or certain other things are by definition sufficient for physical injury. All right, so what are the facts in this case? The facts are the defendant in this case was alleged to have committed a residential burglary, and the victim found the defendant's Facebook post and then told the police. The detective from the police department then brings the defendant to the police precinct to do a lineup, and while he's putting the defendant in the lineup, the defendant allegedly punches the detective in the face. The defendant was then picked out of the lineup. The defendant was charged with burglary and assault in the second degree under the theory that he assaulted the detective by punching him in the course of performing a lawful duty. He was found guilty at trial. The detective testified that it was a very hard blow to the face. He felt pain. This is with respect to the assault charge. It was a very hard blow to the face. He felt pain. He experienced bleeding and swelling. And hospital records described the victim's pain as aching and indicated he was directed to take over-the-counter painkillers. Now, after the defendant was convicted of all these charges, it goes to appeal, it goes to the appellate division, and they reverse it on the assault. They reverse it on the assault charge. They say that testimony and evidence was insufficient. It was legally insufficient to make out physical injury, and therefore assault 2 could not stand. It gets appealed to the Court of Appeals, and they reverse the appellate division. They say, viewing the evidence in light most favorable to the people, in this case, it is sufficient to establish physical injury. So just to go over those factors that would be sufficient if they were present: a very hard blow to the face, feeling pain, experiencing bleeding and swelling. Hospital records describe it as aching pain, and hospital records show that the victim was directed to take over-the-counter painkillers. That would be deemed sufficient for the purposes of physical injury and therefore assault in the second degree. And that's the case of People versus Wheeler. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.